Boston, Whitman, and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel this morning, to my right and your left, is Justice Gabrielle Wolohojian, and to my left and your right, sitting for the last time on panel after a distinguished tenure of service to this court, is Justice Mary Sullivan. We have more visitors in the gallery today than usual. That is because, by tradition, on the occasion of a judge's last sitting, we offer some reflections on their service, and I'm pleased that Justice Wolohojian will have something to say. I want to welcome my colleagues, our colleagues on the Appeals Court. Current and former, Justice Agnes is back post-retirement. I also received a note from Justice Cipher from the Supreme Judicial Court expressing her disappointment that she was unable to attend, but she offered some reflections in a letter that I have given to Justice Sullivan. Justice Wolohojian.
Thank you, Chief. Good morning, everyone. It's my great pleasure to be asked to say a couple of words about Justice Sullivan this morning. Justice Sullivan has been on the appeals court for 12 years, having previously had a long and distinguished career in private practice as a labor lawyer. 12 years, by some measures, is not a particularly long judicial career, but Justice Sullivan's mark on this court will not be measured in terms of the length of her time on the court, because she has used every minute of that time to leave a significant mark, not only through the quality of her work, her contributions to the court, and her involvement in the Flashner Institute, but especially because of her clear voice, always reminding us that our mission is justice. She has been an exemplary judge, a wonderful colleague, and an ambassador of our best values in the legal and broader community. I have shared an office wall with Justice Sullivan for most of her time here. As a result, I have had an up-close view of the dedication with which she approaches her work. No case is insignificant to her. No legal issue is ever tossed lightly aside. No record is too big to be delved into and mastered. Every legal issue is researched extensively with curiosity and an open mind. She follows the same process of deliberate and thoughtful consideration in every case, and she keeps an open mind until a decision is required. She is as earnest and committed today as she was the day she was sworn in. When Justice Sullivan is troubled by something she sees in a case, whether it be a legal issue that has not been adequately briefed, or a hidden flaw in how the case has been presented, or a sadness in the facts, or an unfairness, systemic or other, that is revealed in the case or in the result, she makes sure to give voice to it and, hopefully, to find a solution. Often the problem is something we simply cannot fix or address as an appellate court. This is, unfortunately, often the nature of our work. But Justice Sullivan's judicial philosophy has ample room for the idea that we should be aiming for greater goals, and she has often urged her colleagues to think expansively as she does. As you know, the judges of this court review and comment on each other's draft opinions before they are published. I can't count the number of times Justice Sullivan's comments have been used in this second panel process, as we call it, to bring to the fore some important consideration about the implications the draft might hold, and urge the authoring judge and the court to consider that broader perspective. Justice Sullivan's own opinions are models of careful scholarship, analysis, and clarity. You can, as the saying goes, take a Sullivan opinion to the bank. In addition to her caseload, Justice Sullivan has devoted countless hours to the Flashner Institute, to committee work on the court, and to mentoring law clerks and interns. She always remembers our secretary's birthday, our fabulous secretary, and other important dates. She shares flowers from her garden. She opens her life and her stories about her family to us all. On a personal level, she has been a simply wonderful, thoughtful, and caring colleague. For all of these reasons, I can truly say that Justice Sullivan has made the most of every minute of her tenure on the court, and she will long be remembered and missed as a result. Mary, I know I speak for everyone when I wish you the best in your well-deserved retirement.
Thank you.
Thank you. I will add only a few personal observations to that very eloquent and thorough set of reflections from Justice Wolohojian. Speaking for myself, I can certainly echo everything that Justice Wolohojian said about the care, the thoughtfulness, and the compassion that Justice Sullivan brings to her written work on our opinions. She has been invaluable to this court, not only for that perspective, but also for the depth of her subject matter expertise in the field of employment law. And I shudder to think how we will manage with that loss. In addition to her work on the cases, her work on committees, and in particular on the Personnel Committee, has been invaluable. I don't know what I would have done in my role as chief without her perspective on any number of different matters that come up from time to time in employment and human resources, but also her tireless work on the Personnel Manual. This court recently celebrated our 50th anniversary since our creation. We have functioned throughout that time without a written manual of personnel procedures. That's not a good thing. We are about to change that, and that owes almost entirely to the work that Justice Sullivan has put in. Justice Vuno and our court administrator, Gina Garossi, have made very important contributions as well, but I think all three of us would say that we couldn't have gotten there without Justice Sullivan's assistance. She has also steadfastly been, in some respects, for my purposes at least, the conscience of the court. She is consistently a voice for the voiceless, making sure that we remember those who are disadvantaged, who are marginalized, the poor, the homeless, and otherwise without the opportunities that so many of us are accustomed to enjoying in our daily lives. And finally, she is the driving force behind one of what I consider to be our major recent initiatives, the so-called pipeline project, through which we reach out, recruit, identify, hire, and then support once they arrive law clerks and interns from diverse communities, with a goal not only to expanding the diversity of our face internally and externally, but also the face of the profession as they enter out into the workforce with the kind of foundation that they are able to draw from, having had their experience here. Justice Sullivan, I'm going to miss you.
I'm going to miss you all. Thank you.
Now, you are all welcome to remain for the argument in our first case, our only case on the hearing list this morning. But for those of you who wish to leave before we begin the argument, I'll give you a moment to do so, and then I'll call the first case. You know how to clear a room. The case we will hear this morning for Justice Sullivan's last sitting is case number 2022 P1204, Elizabeth Owens versus Orbelina Erazo and others.
I think
Thank you
this is
for your
appropriate.
patience. Thank you for your patience.
Absolutely. I will just say congratulations. Good morning, and may it please the court. My name is Paul Mitchell. I represent the plaintiff appellant Elizabeth Owens in this matter. As you well know, this medical malpractice matter arises out of care and about care that my client received at the Faulkner Hospital and an injury she suffered on May 8, 2019. The plaintiff did file a medical negligence malpractice claim against the defendants, and the case proceeded to be scheduled for trial. The two of the defendants that are the subject of the hearing today, Nurse Erazo and physical therapist O'Hara, filed for a medical malpractice tribunal hearing, and that was scheduled, I believe, in September of 22. And the tribunal found in favor of those two defendants. And the issue on today's appeal is whether the tribunal's ruling that the evidence was insufficient to raise a legitimate question of liability with respect to both of those defendants was proper. The tribunal found.
I'm sorry to interrupt you. Can you tell me where in your offer of proof you outline the standard of care for, I suppose it would be a physical therapist and a registered nurse?
Right. So, Your Honor, and that indeed is one of the issues that the defendant raised in its brief. And the expert witness, her affidavit, clearly states that there was a deviation from the standard of care. I think implicit in terms of assessing the risk for falls and assigning the level of guarding. I think implicit in that is the standard of care. It's
What is the standard of care?
The standard of care that is with respect to the nurse, Erazo, that she must properly assess the risk for falls.
Can you tell me, because I see it differently. I'm on Record Appendix 314.
Right.
Do you want to pull out don't worry, take your time. I'm looking at paragraph 25 of the expert's affidavit, and maybe it's easier for you. I'm looking at paragraph 25 of the expert's affidavit, and maybe it's easier for you to find it that way than by the page number.
Thank you.
I was thinking that paragraphs 25 and 27, 25 being with respect to the nurse, and 27 being with respect to the physical therapist.
Right.
Am I correct that that's sort of the closest that you get to stating? No?
No,
Okay.
I disagree. I think that the opinion has to be read in its entirety, which is from paragraphs 25 to 30. And so you are correct that beginning at 25, then again at 27, the expert does identify kind of the foundational background, factual background information for her opinion. And then she states at paragraphs 29 and 30 that there was a deviation from the standard of care of the average qualified professionals. And when read, and then she goes on A through subparagraphs, subparts A through H in paragraph 30, identifying the identifying her opinion as to the deviations from the standard of care. F, by failing to properly assess Ms. Owens' high risk for falls by means of the Morse Falls scale, and so on. And G, by failing to communicate with Ms. Owens' healthcare team her high risk for falls. And I think that that is the opinion, of course, part of the opinion, of course, but implicit in that by stating that she deviated from those those practices identifies what the standard of care is. It's akin to this, and I don't mean to oversimplify it, but if an expert witness in a motor vehicle negligence case opines that you shouldn't have gone through the red light, well, it's implicit that the standard of care or the duty is not, that the reasonably prudent person is not to pass through that light. I mean, I know I'm oversimplifying, but that...
It seems to me, though, that that does oversimplify it, because not going through a red light is something that doesn't really require expert testimony.
Well, we could come up with another example where expert testimony may be required, but...
Well, no, but the point here is that I'm not familiar with the Morse-Fall scale, or who it is that develops that, or who it is that's responsible for monitoring it. But somehow, simply saying that it was a deviation from the standard of care not to have that doesn't, without more, root the responsibility for monitoring the Morse-Fall scale in the RN, for example.
I respectfully disagree and believe that and let me explain.
Please.
With regard to Nurse Arazo, she was the nurse on duty. Her responsibility was to supervise the personal care assistant, Mr. Augustin, and communicate to him the physical therapy department's recommended requisite level of assistance. And the allegation of negligence is that the RN failed to properly assess the risk for falls and failed to properly communicate. Now, where in the record is that evidence? And this is what the physician member of the tribunal raised. He said, point to the record. Where in the record does it state that? And it is in the record. It is in the offer of proof, and it is in the appellate brief. Very specifically.
The opinion states, the expert opinion states the breach. I think what the three of us are trying to get at is to what extent is it required or not that the foundation of the opinion be laid out in the opinion, that this is what I'm looking at. I'm looking at my years of experience, or I'm looking at the Morse-Fall scale, or I'm looking at some other standard applicable to PTs, or some other standard applicable to RNs. And as I read the opinion, those bases for the standard of care aren't articulated. It strikes me that's a question of law. Is it required that that standard be better articulated? And if so, or if not, what case do you rely on?
We rely on the Kopaczynski case, 410 Mass 418, which is cited in our brief, and it reads, quote, not all factual questions need to be answered or resolved at tribunal stage. The offer of proof need not include, quote, particularized proof as to the negligence of each defendant individually, quote, as long as the offer of proof states that each individual defendant participated in the care alleged to be negligent. And so that is the case. But in the offer of proof, as a basis for the expert opinion, we reference that Nurse Arazo signed the flow sheet, which is part of the medical record and how the professionals communicate with each other, at 5:14 p.m. and gave the wrong risk for falls for this particular patient. That is at page 66 and 67 of the medical record.
One of the things that confuses me is what role in your theory of the case is there? What is the role in your theory of the case of the changing risk assessment numbers? You see, to me, I understand a theory of your case to be proper information was not conveyed to the PCA, nor was the PCA adequately supervised. I get that. But if that's your theory of the case, then the varying Morse numbers don't make too much sense to me, because I don't understand if information wasn't conveyed that should have been conveyed, then it doesn't matter that the numbers were varying, because I guess your theory is he didn't get any information about giving her adequate support when she was getting out of bed. So can you please explain that to me? You know, what difference does it make if the numbers were varying,
Well,
if your theory of the case is no information was conveyed?
And I understand and appreciate that question. I think it's very good. The difference is this: the varying fall risk assessment numbers are significant because the standard of care requires that a proper fall risk assessment be conducted, and more importantly, that it be communicated to the PCA, Mr. Augustine. And
Your theory is that it
the reasonable
wasn't
inference is
conveyed.
that had the assessment been conducted properly, been recorded in the chart properly, and been communicated properly, then Mr. Augustine would have followed those instructions and provided the proper level of care to this patient.
Well, except there was information in the record of a high level of risk, even at the time that the PCA attended to her, right?
Well, there were varying.
There were varying, but there were some
There were
around
some,
2
but
and
the-
5 o'clock, right?
But the physical therapist who made the, physical therapist O'Hara, who made the entry at 5:01 PM on the flow sheet, which she signed, where she specifically got the guarding level wrong, that was the last entry before the 7 o'clock fall. So it would seem that that is the operative level of guarding that was significant for this particular fall, this particular situation. And with regard, in one of the arguments we make in the brief is that the tribunal seemed to require a particularized proof of evidence of negligence. And as I've stated, I haven't stated, we have provided more than we're required. We did provide particularized proof. We have brought to the court's attention and argued to the tribunal that Nurse Arazo signed the flow sheet at 5:14 PM, and she got the wrong risk level. She got the wrong assessment, and that is evidence of negligence. And that serves as a significant part of the evidentiary basis for the medical negligence claim. Again, that's at page 66 and 67 of the medical record, and it's discussed at pages 10 and 11 of the offer of proof. With regard to physical therapist O'Hara, again, we provide particularized evidence of the proof, and that the physical therapist got the assessment wrong. At 5:01, when she signed the flow sheet, getting the guarding level wrong. Again, that's discussed at page 43 to 43, 48, 62, 69, 84 to 88 in the medical record, as well as page 11 of the offer of proof.
Your criticism of the way that the tribunal approached the offer of proof rests on a characterization of the reasons underlying their decision that is not clearly articulated by the tribunal itself.
Yes, and I think we addressed that in the reply brief that we filed with the court and with the Cooper decision. And I believe that discussion, the question by the physician member of the tribunal, when considered in light of the expert witness's affidavit and finding, lead to the conclusion that
Well, to the same extent, I suppose, that you could infer what we're thinking from our questions here this morning.
But it is different because in the case at hand, we have the decision of the tribunal, and we also have the benefit of looking at the affidavit and considering it in light of the Kopaczynski case opinion and the standard there. That case, as you well know, discusses the sufficiency of an expert affidavit, not requiring particularized proof. And I believe that the affidavit does satisfy the plaintiff's burden for purposes of the tribunal.
I see that you're reaching the end of your time. Thank you.
Okay, yes, thank you very much.
Good morning. If it may please the court, Megan Kiris on behalf of the defendants Orbelina Arazo, RN, and Lauren O'Hara, PT. I would also just like to take a brief moment to congratulate Your Honor. Thank you. It's our position that the tribunal that reviewed this matter acted well within its statutory mandate in reaching the decision that it did. I think counsel is correct that the tribunal is not tasked and should not weigh the evidence before it, and also the plaintiff is not required to present particularized evidence, but part of the very responsibility that the tribunal has is to review the sufficiency of what is set forth in the plaintiff's offer of
So
proof.
I've really been struggling with this because
Sure.
I don't think that the tribunal could have reached the conclusion that it did unless it made some essentially factual determination sub silentio that it's not supposed to make. And so try this one on. I think the plaintiff's case is sort of two alternate theories. One is the PCA was properly given all the information the PCA was required to have, and it was just something that the PCA messed up and everything followed as it did. Or, and that seems to me the defendant's position, or the alternative set of facts is the PCA was not adequately given the information that he or she should have been, followed what he or she was told, but what he or she was told was inadequate, and as a result, everything that followed. So how could the tribunal, if I'm correct about that, doesn't the tribunal's decision necessarily rest on a determination that it's the first scenario that occurred rather than the second scenario?
You know, I don't believe so, Your Honor. I think part of the tribunal's responsibility is, and this is, I think, important, it's not weighing the evidence. But I think one of the things the tribunal has to have the ability to do, or otherwise, frankly, there's no reason to even have tribunals, is that they also have to consider what the evidence is that the expert is looking at. And part of that is a determination as to whether or not it's a factually based statement versus something that is predicated simply upon speculation or conclusion.
No, but when it's a case of a negative, right, something didn't occur, which is what this case is, right? So you're not going to see something. And the expert opinion is it should have been conveyed, right? It's just conveying information. Person A has information and a responsibility to convey it. Person C doesn't have the information. I take it that there's nothing in the medical records that shows an active act of communication of the contact or whatever that you call the instruction.
Certainly,
to the
certainly.
PCA.
So I don't think that that's completely accurate, Your Honor. I think what is important here, and I think it's something that the tribunal did pick up on, which is that this expert never articulates that the standard of care, the expert makes sort of a generalized statement that the standard of care required communication.
25 and 27 paragraphs look to me like averments of what the standard of care was.
But I think a generalized statement that something requires communication, if you look, for example, at the Bradford versus Bay State ambulance case, the SJC specifically states that generalized statements regarding communication that should have happened are not enough.
But what about this? Because in 25, it says the defendant Orbelina Erazo, RN, as the nurse on duty, was responsible and accountable for supervising the co-defendant, the PCA, and reviewing and communicating to him physical therapy recommendations concerning the requisite level of assistance with mobility. And as part of her supervisory role, the nurse was responsible and accountable for ensuring that the PCA was not allowed to manipulate or disconnect any intravenous tubing due to his lack of adequate qualifications. That seems pretty specific to me.
Well, Your Honor, in the records themselves, it is clear, and the tribunal noted this, that there is statements from both the physical therapist and from the nurse as to the level of assistance that is recommended. That's set forth in multiple places within the flow sheet and also in the consultation note that's authored by the physical therapist. And what the expert does not state is that the standard of care required something more than that. And I think that it's also important to look at the causation aspect of this. So one thing that is important to note is that nowhere in this expert's opinion does she articulate that what P.T. O'Hara specifically recommended, and it's important to remember that these are recommendations that are made, that the recommendation that she utilized, contact guard assist with one person, was wrong. Her whole opinion as to the physical therapist is this sort of amorphous allegation that she failed to properly relay her recommendations to the rest of the team. But nowhere does it say what that would have required of her, or that the way that she relayed it, i.e. through the documentation in the consultation note and through the flow sheets, was below the standard of care.
Well, what if you were going to have discovery and the PCA says, I was never trained to look in the medical records to see what I'm supposed to do. I was trained to follow the verbal instructions, the oral instructions of the nurse. And she never conveyed any of this information to me. And I'm only raising that hypothetical because it seems to me, even when I hear you explaining your answers to me, that they all reduce to a question of fact, which is not what the tribunal's supposed to be evaluating, as I understand it.
I don't believe that these are, in fact, reduced to questions of fact. I think they're, again, reduced to looking at the sufficiency of what is in front of the tribunal panel, and the statements of the expert have to be factually based. And one of the things that's important to take into consideration, and there's multiple decisions that recognize this decision, or this principle, both from this court and also from the SJC, and that is that the expert in formulating their opinion, it's not just that it's enough for the expert to come and say, this is what I say the standard of care is, this is what I say the breaches are, this is the injury, and voila, we have enough to get past the tribunal. That's not enough. Again, that's not what the statute states, and it would really, again, gut the whole purpose of having the tribunal. So I think what's important to consider here is that what was in front of this expert when she was formulating her opinions was the information that was contained in the records. And the records do not support, at the end of the day, what it is that she is ultimately claiming. And I think there's multiple aspects of her opinion that are just, they're rank speculation. So again, I want to reiterate this point because I think it's important. As to P.T. O'Hara, she never articulates that her recommendation of one-person contact guard assistance for getting this patient out of bed was negligent. Then she makes the leap that had Mr. Augustin, the PCA, been properly instructed, that he would have complied with that and with a higher level of protection than he provided. The problem is that he didn't follow the information that he did have as articulated in the records. So I think it's wholly speculative in nature to suggest that if this sort of amorphous standard of care had been complied with, that it would have resulted in some different outcome.
Is it speculative or is it a dispute of fact? I mean, that's what we're looking at here. I understand, and you're making a very eloquent argument for how you would argue this case outside of the tribunal, but what troubles me about the tribunal's decision is that it says that this is simply an unfortunate medical result, when we know that the alternative theory pertaining to the other two people who did not ask for the tribunal is that saline, or the saline bag was dumped all over the floor and she slipped on it, which, you know, if that happened in a grocery store, you wouldn't need an expert to say that that was negligence. So I'm even struggling with how we get to the determination by the board that this was an unfortunate medical result, because it just seems internally inconsistent with the fact that there are two other people, one other person in the hospital is going to trial. So
Certainly, Your Honor, and I appreciate that perspective, but I think you actually raise an important point, and that is that in looking at the case when it's before a tribunal, it's not a sort of one size, one shoe fits everyone. So you're right, Your Honor, that there is evidence that's set forth in the offer of proof and that there is a theory articulated by the expert that pertains to two other defendants whose conduct is at issue.
but where's the evidence of unfortunate medical result?
But I think, and again, this is with due respect, it's oversimplifying.
You don't have to say that, it's okay.
It's oversimplifying.
And I won't be around to bother anymore anyway, but you never have to say that.
I think it's oversimplifying, again, sort of the whole tribunal process, because you can't look at one defendant. Let's say we have 4 defendants, and again, this is just for the sake of this argument. Let's say one of them is clearly negligent, right? And that resulted in some harm to the patient. You can't hold everybody else negligent just by
Of course
association.
not, but how do you write that it's an unfortunate medical result? Because it's clear, you know, if you take your hypothetical and one person was clearly negligent, it isn't an unfortunate medical result.
But part of the, I mean, if you're looking at the actual piece of paper that the tribunal prepared, it's a form document, and frankly, I will tell you as somebody who only practices medical
It's inscrutable.
malpractice.
It tells us nothing.
Right, it tells you nothing, and it's what's always circled
Which,
regardless.
by the way, is another layer of frustration for us in trying to conduct this exercise.
I understand.
But let me also go back to something that you've been saying in response to to Judge Sullivan's questions, because it confuses me. Are you suggesting that the evidence that Augustine didn't look at the medical record absolves Nurse Arazo, even if she had failed to put what she needed to put into the medical record pursuant to the standard of care?
Yeah, I'm not entirely sure I understand your question.
Suppose we could demonstrate what the standard of care was, and that Nurse Arazo failed to follow the standard of care in completing the medical record that was transmitted to Augustine. But Augustine didn't look at the medical record, and so it breaks the causal link between her negligence and the injury that resulted from Augustine's acts. Are you suggesting that that break in causation in the prima facie case of the offer of proof absolves Arazo of negligence?
But I don't think that the expert has articulated that what she recorded in the medical record was wrong and that she was required to do
That's a
something
different
else.
point. That's a different point. Maybe I misunderstood what you were saying in response to Judge Sullivan's questions, but it sounded to me as though you were saying that it didn't matter because Augustine didn't look at the record anyway.
No, I don't think that's what I said, and I may have not articulated my point very well. The expert is reaching her opinion in this case by looking at what happened and then trying to hold 2 other defendants who were not involved in that specific aspect of the care. So, for example, she hasn't articulated with respect to the supervision aspect of her claim against Nurse Arazo that Nurse Arazo was required to be in the room with Mr. Augustine and to supervise him as he handled the patient. So what she's looking at here...
No, but she did say that she's responsible and accountable for ensuring that Mr. Augustine was not allowed to manipulate or disconnect any intravenous tubing.
But what is missing from that is what is it that she did that somehow resulted in what happened? There has to be some link that is there.
There's been no discovery. This is, all of your questions make total sense to me if we were in a motion for summary judgment, but pre-discovery, the issue we have to grapple with is how much of a burden do we place on the plaintiff at the tribunal stage, which is supposed to be winnowing out the frivolous claims. I think your questions are very legitimate, but are they the ones that we have to be answered at this stage?
I think that there does have to be some onus on the plaintiff in an offer of proof to make factually based statements that support the claims that they're setting forth. And I understand the frustration that you have related to the fact that there's no discovery conducted in these cases at this point. However, if there's a requirement that there has to be discovery or something more, then what's the purpose of the tribunal? The plaintiff's not without...
I'm not frustrated by the lack of discovery. I'm just saying I think it poses a question of law.
I understand
your red
position,
light
Honor.
is blinking.
Unless there are further questions from the panel, that will bring this argument to a close, and with it our abbreviated session this morning with only the one case, and with that, the distinguished tenure of Justice Sullivan sitting on panel. The case is submitted. We are in recess.
Thank you.
All rise, please.
Thank you.
Court is now in recess.